Yes, Ms Gilroy.
My Lord, yesterday I asked you to look at Osborne.
Yes.
In order to highlight my first point, which was that the Divisional Court overlooked the rationale for procedural fairness in concluding that individuals did not need to make representations or did not need to be given an opportunity to make representations on general safety. And in my submission, having looked at those passages of Osborne, it is clear that not allowing individuals to make representations on the critical issue underlying a decision, even though that is relevant to the decision, and even though they have something relevant to say, and we know that because the quashing of the majority of the decisions in the linked claims by the Divisional Court makes it clear that they had something relevant to say, does not contribute to better decision making, and it undermines the rule of law. It is also impossible to say that the process that was followed prior to the June decisions, that's the first set of decisions that led to the removal directions on the 14th of June, it's impossible to say that that procedure paid those concerned due respect as required by the Supreme Court in Osborne. People were threatened with removal, and some were put on planes before they could produce the highly relevant evidence which has now led to the decisions in their cases being quashed. They had something relevant to say, and they were not allowed a fair opportunity to say it. And my Lord, in the supplementary bundle, which is in Asylum Aid's case, which is unique number 15, supplementary bundle Asylum Aid, at tab 1, there is a table which I'm going to make reference to at various points in my submissions, and I just want to show you how it works.
So which page is it?
It's page 3 of that bundle.
Yes.
And what you can see is a column. The first column is the name of 10 claimants. That's 8 on whom the Divisional Court ruled, and 2 which were claims before the Divisional Court but were stayed.
Sorry, I'm being slow. I'm in bundle core 15, or no, sorry, common bundle 15.
Supplementary bundle 15 in
Sorry.
Asylum Aid case. Sorry, it's unique bundle 15.
That's what I meant, sorry, yes. Which page?
Page 3.
Thank you, yeah. Yes, thank you.
And the first column is the claimants, and the second column highlights the evidence that they were able to produce before the June decisions, or the representations that they were able to make. And as you will see, and I'm not going to go through it all now, but it's for your note, as you will see, only one individual was able to produce a witness statement which addressed torture and mental health concerns. 3 others had disclosed torture in interviews and detention to the Secretary of State's officials or doctors, 2 of which led to Rule 35 reports. No individuals of the 10 were able to produce medical evidence or country evidence, and 9 weren't able to produce any witness statements. 6 made representations, but most of those were holding representations. There just was not enough time to engage with the issues. My Lords, the second error in the approach of the Divisional Court is that it fails to appreciate that the right to make representations must be meaningful and of value. That means that those with the right must be enabled to make representations which are capable of making a difference to the decision. That's the central reason why courts have concluded that fairness often requires the disclosure of the substance of a case against an individual. And my Lord, that is clear from Doody, which is, and I'm not going to turn it up now because I'm going to turn it up later, at Supplementary Authorities Bundle 1 in the Asylum Aid case, which is unique 27, at 563F to H, page 335 of the electronic version, where the court said the right to make representations is of little value unless the maker has knowledge in advance of the considerations which, unless effectively challenged, will or may lead to an adverse decision, and without it there is a risk that some supposed fact which he could controvert, some opinion which he could challenge, some policy which he could argue against, might wrongly go unanswered. My Lord, I read out this very well-known passage because the Divisional Court's conclusions do not recognise this. Quite the opposite. They say it said in terms, at paragraph 392 of the judgment, that procedural fairness, quote, does not require that an asylum claimant be put in the position to second-guess the Home Secretary's evaluation on general safety. But in my submission, that is exactly what is required. Thirakumar says so in terms, and I would like to turn this up. It's in the Supplementary Authorities Bundle 1, tab 8. That's volume 27, page 296. .409 in the speech, the judgment of Lord Donaldson, Master of the Rolls. Under the heading Unfairness, if I could just ask you to read from if the Home Office decision had been irreversible.
Which page are we on?
Page 409 or 296 of the electronic, of the bundle.
So simply that one paragraph.
Just
You
one
want us to
paragraph.
read? Yep.
My Lord, the point there is that if information, relevant information could emerge that is capable of affecting the decision that would cause the Home Office decision, which was provisional in that case, to be reconsidered, then individuals must be given an opportunity to produce it and must be given sufficient notice that they're of the provisional conclusions that they're able to deal with it properly. The Divisional Court acknowledged that the Secretary of State must consider relevant and material information provided by individuals. That's also at paragraph 392. The Divisional Court said the Home Secretary should have regard to them, and the Secretary of State's detailed grounds of defence made this plain too. And I would like to turn that up because, again, this is an important passage. It's in Common Bundle 2. So that's the Common Documents Bundle in all the places. It's page 316. Paragraphs 5.21 to 5.22. And there the Secretary of State says that as the decision letters dated 5th of July 22 demonstrate, decision makers can have regard to material post-dating the CPINs and the assessment document when deciding whether Rwanda is a safe country. That new material may come from individuals. And then they quote at the end of that paragraph, that's in line with the inadmissibility guidance, which makes clear decision makers should review the evidence available, including any representations made on behalf of the claimant. And then at 522, this is, there is no purpose in challenging the CPINs or the assessment documents. Such documents are helpful to decision makers in the court. but they are inevitably limited to an assessment at a particular time and they do not purport to be exhaustive. The remedy, if a claimant believes the CPIN information to be wrong, is to make representations to that effect to the Secretary of State. If the Secretary of State decides to reject those representations and give weight to the CPINs or the assessment document, the remedy is to bring a judicial review of that decision in relation to that individual. So submissions in advance will be taken into account, and then the challenge can be brought afterwards. So applying thorough QR, individuals must, as a matter of fairness, be given an opportunity to make those representations that can make a difference and to which the Home Secretary must have regard, can have regard, and must have regard. And we can see that how important and relevant that information is from the judgment at paragraphs 203 to 4, and I'm not going to ask you, this is for your Lordship's note, 203 to 4 and 216 in the Common Documents Bundle, Volume 1, page 89 and 93, and it's not, as this court knows, the decisions were quashed in individual cases for failing to take account of the UNHCR evidence. And my learned friend showed you one of the paragraphs in one of the cases, paragraph 285, yesterday. It's another example of that. The third error in the court's decision was to conclude that it was a non sequitur for asylum aid to say that representations must be able to address relevant matters. That's what the Divisional Court said at paragraph.
Sorry, could you just say that again? It was a non sequitur.
For asylum aid to submit that representations, the right to representations, was a right to address relevant matters in the decision.
Where does it say that?
In paragraph 392 of the judgment.
Oh, I see, that's where we were before.
It's where we were yesterday. There's a very long paragraph, and one of the things that is said in that very long paragraph is that asylum aid's submission is a non sequitur.
Can we just see the context in which it
Yes.
says it?
You'll see, I hope your Lordship can see it, it's at page 135, just before the end. It is not enough to say that criteria 2 to 4, those
Sorry,
are the general.
I don't have the page. I've dropped the judgment.
It's paragraph 392.
The bottom of the page, you're saying?
It's sort of, if you're looking at the whole paragraph, it's near the end. It's about 7 lines up from the bottom of the page. It is not enough to say that criteria 2 to 4 are relevant to the decision to remove.
These are the criteria in the rule.
Those are the criteria in the rules which go to
Yeah.
a full model of general safety. And
Sorry, I must be 7 lines up. Have something saying criteria 2 to 4 within paragraph 354B of the immigration rules are different. It's in paragraph 392 of the judgment.
Yes, I think somehow your bundle is different. It's a bit below that bit, my lord.
Yes, your page layout is different from mine.
Oh, I see.
It's just a bit below that. It's 2 sentences beyond, 2 or 3 sentences on. It is not enough to say that criteria 2.
Oh, I've got it. I got that at the top of the following page. Well, that's very
I'm
odd.
so sorry, my lord.
Simply a printout of the judgment. But still. Anyway, thank you. I have it.
And since the asylum claimant is the subject of that decision, he must have a legal right to comment on those matters before the decision is made. It's not enough to say they're relevant. That is a non sequitur. It's not explained why it's a non sequitur, and in my submission it plainly isn't a non sequitur, but it's also inconsistent with the authorities, and I'm going to just give you some quotations. But it's something that the Secretary of State has picked up, as I mentioned yesterday in her skeleton argument, paragraph 42. She says, none of the authorities establish a general right to make representations in every case by reference to a touchstone of relevance. And in my submission, both the Divisional Court and the Secretary of State are wrong. I've already shown you in Osborne, Supplementary Authorities 2, tab 22. I don't intend to ask you to turn back to it, page 925 to to 6, but repeatedly in that judgment, relevance is said to be the key issue. It's at paragraph 67. The virtue of fair decision making is better decisions because it ensures the decision maker receives all relevant information and it is properly tested. At paragraph 68, the passage I highlighted yesterday, respect requires that a person with something to say which is relevant to the decision be given a chance to participate in the process. At paragraph 71, again, the rule of law requires that decision makers should listen to persons who have something relevant to say. And then in Arledge, again, I don't intend to ask you to turn it up. It's at volume 27, Supplementary Authorities 1, tab 2, Local Government and Arledge, page 24 to 5, paragraph internal page 133, quoting the Board of Education and Rice, the decision maker was, in that case and in every case, under a duty to act in good faith and to listen fairly to both sides, inasmuch as that was a duty which lay on everyone who decided anything. And as to how that should occur, the House of Lords stated the board need not examine witnesses, because it wasn't a court. It could obtain information in any way it thought best, always giving a fair opportunity to those who are parties to contradict or correct any relevant statement prejudicial to their view. Again, relevance is the critical issue. Similarly, in Kanda and Malaya, in tab 3 of the same bundle, page 58 to 59, internal 337, the police inspector facing dismissal from his job must know what evidence has been given and what statements have been made affecting him, and then given a fair opportunity to correct or contradict them. Again, relevance, the statements affecting him. Similarly, in Ridge and Baldwin, pages 92 to 93, tab 4 of the same bundle, quoting Diverte and Nags. I hope I'm not going too fast. The acting governor, considering a complaint, had a duty of giving to any person against whom the complaint is made a fair opportunity to make any relevant statement which he may desire to bring forward, and a fair opportunity to correct or controvert any relevant statement brought forward to his prejudice. And I've already shown you Therakuma, which again refers to further relevant and material information. So, my lord, relevance is the key question. Individuals, as a matter of fairness, must be given, applying the Doody principles, an opportunity to make relevant representations. There is no limitation in any of the authorities to relevant information which is specific to the individual, which is what the Divisional Court concluded. There is not a single case which draws that distinction. And I've already, without turning back to Therakuma, in his judgment, Lord Justice Bingham, Master of the Rolls at the time, a person must be told, this is at 414, page 301, the considerations which will, as matters stand, defeat his application. No limitation except relevance. Duty is the same. In Inri D Minors, which is at, I'm not again going to ask you to turn it up, but just give you the references, tab 10, volume 27, Supplementary Authorities 1, at pages 351 to 2. This is an authority quoted in the skeleton.
This is all going very fast.
Yes.
Is this all
in your skeleton argument? Yeah, well, all the references are in the skeleton argument.
Right, well, that's
but the relevance.
Right. Which? Thank you.
So it's in. I should have said at the start that please do have that because all those.
Well, I was trying to find where we were in your skeleton, but I couldn't marry it up.
Well, the relevance issue is a matter that has been picked up by the Secretary of State, so I haven't categorised it in those terms in the skeleton argument. But what you can see is duty.
You know, obviously, these are all very familiar cases. I know.
Yes.
I just wanted to know roughly where we were in your skeleton, so I can.
Well,
spot
I think
them.
the answer to your question is we're not in my skeleton.
Okay.
These points on relevance, so I do
Okay.
apologise.
Thank you.
So in Re D minors, I should give you the reference more slowly. It's 1996 AC appeals cases 593 at 603H to 604A, page 351 to 2 of the supplementary authorities bundle. And the obligation is to provide an opportunity to answer by evidence and argument any adverse material which the tribunal may take into account, whether that material is of general application or is specific to an individual. And my lord, this is in the skeleton argument. It's paragraph 15.
14.
Paragraph
14.
14. Oh yes, in Re D minors is in 14. Yes, I'm grateful, my lord. But turning to paragraph 15, I've set out there several examples of authorities where it's clear that the information required to be disclosed or on which representations needed to be made was not specific to the individual.
Well, this is all very general, and I would thought, speaking for myself, incontrovertible. But what is being suggested, I think, by the Divisional Court, is that in practical terms, it is important to draw a distinction between general conclusions as to procedures and so forth in Rwanda, about which it is unlikely, not impossible, but unlikely that there will be anything useful that individuals will have to say once there has been a decision of this of the court, which there already has been and will be again. Whereas they will have a lot to say about their own circumstances and how they fit into that framework which has been held by the court to be a reasonable assessment, let's hypothesize. Isn't that a reasonable distinction to draw?
Well, my lord,
I'm talking practicalities about, because this all feeds into the question they're not given enough time.
yes.
They're not given enough time to do original research into the state of affairs in Rwanda. In the real world, that's not likely to be a useful exercise for them to do.
Well, my lord, it's important to look back and at what asylum aid is actually and was actually challenging. Because what the court has found, which was a finding that is applicable to all the individual claimants who went through this process in June of 2022, it's not that in the future, which wasn't asylum aid's challenge in any event, it's not that in the future, if there is a definitive judgment of the court, at that stage it will be appropriate to have a shorter time scale. And I'm going to come on to whether there will be a definitive judgment.
Surely your challenge is to the system.
It's to the system that was in place for those decisions. And the court has found that the system that was in place for those decisions was lawful. That's what the court has found. Now, it has also said, in the future, we think that things will be easier anyway because of the judgment that we are making. I'm going to come to whether that was a legitimate conclusion.
Well, it's like a country guidance.
So,
Like a country guidance case in the upper tribunal where
yes.
one doesn't expect every appellant in the first tier tribunal or the upper tribunal to cover the ground in a country guidance case unless there's a change. I mean,
That's
isn't
right.
that what the court was really saying?
Well, not, my lord, I think at this point it is important
Well,
to look at what they were really
All
saying.
right, well,
Because-
So sorry. I'm so sorry.
Yeah, but we'll do that. But if that is the import of what they were saying, big if, so we'll look at it, is there anything wrong with that?
Well, there is, my lord, because in fact, the submissions that I made to the Divisional Court were that whatever this court concluded, and this court on appeal concludes on the general safety of Rwanda, there will in fact still be huge evidential questions around the general safety of Rwanda that will be live. And that is because of the nature of the finding that the court is making, which is based and being asked to make by the Secretary of State, which is based on monitoring. Now, as your lordships will no doubt have appreciated from the defence of the Secretary of State and from the judgment itself, all the upholding of the general safety of Rwanda is based exclusively on promises or speculation
I had
about what will
understood
happen in the future.
I may have misunderstood this completely, but I had understood the Secretary of State's position as articulated in the skeleton argument to be that if anything new arises in respect of Rwanda, then of course anybody can draw that to the Secretary of State's attention, and that if time is needed, then the policy enables extensions to be given.
Well,
have I misunderstood that?
Well, my lord, I'm going to come to extensions, but as things stand, there is a 7-day period of time, and it is impossible for individuals to prepare evidence about how the policy is going to be implemented in the future in that period of time. And because everything that is said about this policy is about monitoring in the future, and also it's new, it is necessarily going to be relevant to any future decision on the compatibility of a decision of a removal decision with Article 3 or the Refugee Convention, to look at what's happened. Let's assume people are removed, to look at what happens to them. Now, someone is going to have to gather that information. And as things stand, there is still only, and this is what the Secretary of State is seeking to uphold for the future, but also for the past. This is a decision that applies to the past, and my learned friend, Mr. Drabble, will be addressing how there's been a decision that it was fair in his client's case. This is a backward-looking as well as a forward-looking.
Well, is it really?
decision.
Your part of the case is the forward-looking part, surely. All of these individuals have been held the process was not fairly applied in their cases.
No.
The value asylum aid brings to this case is to talk about the system overall, and it doesn't bring any value if it merely adds to the points made for the cases which have already been decided.
Well, my lord, it doesn't. First of all, the court has not found that any of the cases were decided unfairly. They have quashed the decisions for other reasons, but they've expressly found in that part of the judgment, at paragraphs.
Never mind. The fact is that their cases are going to have to be looked at again.
Well, that is right.
And they will have to be looked at again fairly in the future.
But what the court has found is a point of general principle, my lord, which is that it's not necessary, not because there's been a judgment of this court, it's not necessary as a matter of law in the context of this procedure, looking at the immigration rules, not at their judgment, it's not necessary for individuals to be given an opportunity to make submissions on general safety. Now that will apply even if, this is why it's important for what goes forward, that is a point of principle, it's not a conclusion on the situation that may arise on monitoring or not. Even if copious evidence were to be relevant to a future decision on removal, the Divisional Court has found that individuals should not be required to have an opportunity to address it. They are not required to be given an opportunity to address it. That is the Divisional Court's finding. And it's that point of principle that's important.
Could you help me with the paragraph where that's to be found?
Yes, it's at 392, 389 and 392 of the bundle.
Yeah. Okay. Thank you.
My lords, I'm going to one of the, before I come to, so 392, you can see, actually, if my lords could look first at 389. This is an analysis of the rules and the context. It's nothing to do with whether there's a judgment or not. Fairness did not require, and this is past looking, an opportunity to make representations in response to the Home Secretary's evaluation or provisional evaluation of that explanation.
Sorry, where's that?
This is at 389. This
What
is on.
fairness required?
Sorry.
Oh, fairness, I've got it. Fairness did not require. Yep.
This is on inadmissibility. And then at 390, fairness requires a claimant to have the opportunity to explain why in his case the right to life and liberty would be threatened if he were removed to Rwanda. That must be an opportunity for him to put forward reasons why his specific situation is such that he should not be removed. In the present cases, so this is all backward looking and looking at a situation like the one that was in front of them, not like the one that would occur in future. The notices of intent given to each claimant request representations on each of these matters. Therefore, in the present context, fairness did not require the Home Secretary to provide each claimant with all the information she relied on to form her general opinion on Rwanda. For example, that Rwanda meets the criteria in 345b2 to 4 of the immigration rules, and fairness did not require that each claimant have the opportunity to make representations on these matters.
That's the fine. That's what you're criticising.
Yes.
392 is an elaboration.
392 then goes on to explain why, and also rejects arguments that were put by asylum aid. But that is the finding. And in my respectful submission, that cannot possibly be right. Now, it's true that at 395 they then say, furthermore, it is also right to note for the future that any generic issues raised by the claimant and so on. That's the point I'm making. So that's a separate.
Yeah,
set
I
of
just
issues.
forgive me for
Yes.
trying to get to the bottom of the context of these observations. There's a distinction drawn between paragraphs 1 and paragraphs 2 to 4 in the rule.
Yes.
Clear. Then towards the bottom of the page, there's an observation that, of course, let's read it. This is not to say that any individual faced with the possibility of removal to a safe third country could not seek to persuade the Home Secretary that one of the other criteria was not met. So, and that if such representations were made, the Home Secretary should have regard to them.
Yes.
Do we draw any of the context of this from what's said towards the end of paragraph 392, which seems to be that the court thought it was dealing with a submission that the Home Secretary should provide to everybody, quotes, all the material available to her, close quotes. The legal duty to act fairly does not in the present context require an asylum claimant to be put in the position to second guess the Home Secretary's evaluation. So what part of the submission was that there should be huge disclosure as it is. I don't know that the Secretary of State uses the word huge, but that's
Voluminous
the context.
is the word that she uses.
Voluminous, all right.
Yes.
It's a longer word, but means much the same thing. So was that the submission?
No, it wasn't. And I think at this point it's important to go and look at the transcript, because as your lordships will have, I hope, gathered from the skeleton argument, the Secretary of State's position and the claimant's position, asylum aid's position, was ad idem on this question before the Divisional Court in all the pleadings up until the second day of the hearing.
Will you explain that in your skeleton?
I do.
Yeah.
And what then happened is that the Secretary of State was asked to reconsider her position because the court was not convinced that it was correct on that question of representations on general safety. And in that reconsideration, you can see the court recording what submission I made when I was asked by them what disclosure I thought should be made in advance, and it was the CPIN, which was already published online. The MOU, also already published online, but none of these were at the time being given to individuals directly, but they were published online. The note verbal, which were not made available to anyone before their decisions in June. And in addition, I said if there was strong undermining material for the CPIN, so in other words, there was, as my lords will have picked up from my learned friend's submission yesterday, heavy internal criticisms, government criticism from the FCDO, of some of the conclusions in the CPIN, not properly representing the position. And I said that those suggestions that the material was misleading would have to be or ought to be disclosed as a matter of fairness. And what the court said about that was that if fairness did require representations to be made, and you can see this from the transcript, which I can see what you're worried about time. So it's 488 and I'm worried about time.
Yes.
488 and 491 of the supplementary bundle.
Have you got a bundle number?
It's 15.
Thank you.
488 and 491.
And by misleading, what do you mean? Well, misleading is entirely different from two people having a different point of view.
Well, if it gives the impression that if the CPIN material gives the impression that there is a view that something is safe, when researchers that they have asked about this question, like the Foreign Office with expertise, are suggesting that it isn't safe, then the case law on CPINs, like Karouche and so on, suggests that actively misleading comments should be qualified. And the usual practice in CPINs is to include both sides of the story for exactly that reason. And so it's that sort of undermining material that Asylum Aid suggested should be disclosed.
Yes.
But that was, I emphasise, a subsidiary part of the overall submission, which was about timescales. So the main part of Asylum Aid's submission was that it wasn't, not that there was a disclosure problem, although that made it even more unfair in Asylum Aid's submission. It was that there wasn't enough time for individuals to prepare their own cases.
Yes.
My lords. So that is why this point of principle around submissions on general material is still important for future cases, because, as I say, it's, first of all, it was Asylum Aid's submission that future cases could involve an enormous amount of evidence, notwithstanding any conclusion on general safety, because of the nature of that finding. And if that were to happen, the Divisional Court's judgment would still preclude individuals from doing so if the Secretary of State did not want to give them more time, because she's not required to, according to the Divisional Court, as a matter of right. So, my Lord, can I just make my fifth point? This is, so I've already highlighted at paragraph 15 of my skeleton the examples of the distinction between general and specific not having any basis in the case law, and I'll leave those submissions with your lordships. But the fifth point is that the distinction the Divisional Court draws between general and specific matters doesn't work in practice. And that is because the Secretary of State's answer to both general safety and individual circumstances is the MOU and the note verbal. And you can see that from the decisions, some of the decisions in this case. And I would like to give one or two examples so that your lordship can see. So it's at volume 7 of the core bundle, in the AAA cases. So volumes, I think it's volume 7.
Yeah.
Is this the common?
It's it's AAA core bundle.
It's a common bundle. It's AAA specific.
It's AAA specific, yes. And so it's at 640.
That's tab 16, I think.
It's tab 16, I do apologise.
Oh, don't worry.
Tab 16, 640.
Sorry, you'll have to give me a moment because by chance I took that out and put it somewhere else.
AA Core 2.
Okay, I have it now.
What bundle are we in? Bundle what? 7.
640. This is starting at 640, and you can see at paragraph 72 under the heading "Your Individual Circumstances," reference to depression, anxiety, and panic attacks, and so on. And the answer, as far as the Secretary of State is concerned, to those individual circumstances, is the MOU and the associated note for BAL. And you can see it again on inability to speak English or other languages commonly spoken in Rwanda, 76.
So that's 75 and 76.
75 and 76. And this goes on 92 to 94. Consideration of any risk to your health, this is at 643. And the answer again is at 101 to 104. It's based on the CPIN and the note for BAL.
Yes.
And my lord, without, I don't think this is going to, it cannot be controversial, so I won't, unless your lordships want, ask for any, give you any other references. But this is a theme throughout the decision letters. The answer to individual circumstances and general safety is the note for BAL. So realistically, it is not possible for people to make effective representations, even on their individual circumstances, without having sight of and being able to make representations on the general question of the reliability of the MOU and the note for BAL, and also the CPIN. So there isn't.
But I mean,
yes.
A bit of shadow boxing in a way, isn't it? Because you get this so often in this sort of case. There will be general information relied on by the Home Office. There's a functioning health service in Mauritania. And the argument may be, well, there is, or maybe, but I have a very specific condition which can't be treated there. It can only be treated in London.
Yes.
And those sorts of points clearly have got to be able to be made. And I don't think it's been suggested they can't be, is it?
No. But my lord, what is being said is that there is not a need to give people an opportunity to make representations about general matters, like the note for BAL and the MOU.
But it will always be specific in one sense.
Well, it will. Yes, that's the point. In my submission, there is no, and this was my next submission, is there is no clear distinction between general matters that apply to us all asylum seekers and individual matters. There is in asylum claims, there is a crossover always between the specific and particular circumstances of an individual and the general assessment of a decision maker in the either in the courts or in the Secretary of State's Department about whether people in that category or people with those characteristics will be at risk. And the only situation where there is a neat divide between them is where there is a presumption in a statute. And this is where the approach comes from. And where there is a presumption in the statute, then that gives rise to a whole range of consequences about the ability to investigate those presumptions. But otherwise, the approach is always, in decision-making, to assess the general alongside the particular, because it has an impact. All of them, those questions, are relevant to an individual and to the decision as to whether it's lawful to remove them or not. So, my lord, before I leave that letter, can I ask you to look at paragraphs 162 to 163? Because that is where there is an assessment of the reasons why your human rights claim is clearly unfounded.
Which pages are these?
This is at page 652. It's in the same letter, 162 to 163, tab 16. Your human rights claim is considered to be one which is bound to fail. To reach this decision, consideration was paid to the decision of the Court of Appeal in FR. Having given careful regard to the facts and the evidence you have submitted, we have decided that on any legitimate view of the evidence, the outcome of your claim would be the same, and your human rights claim is clearly unfounded for the following reasons. So, my Lord, my final submission on this question is that when it comes to making an assessment, as the Secretary of State must do under Section 19C of Schedule 3 of the 2004 Act, about whether an individual's claim is bound to fail, she is required to look forward to what evidence, what arguments could be made in front of the tribunal. And in my respectful submission, she cannot fairly do that without giving the individual an opportunity to articulate that evidence, to articulate those arguments and produce at least some of that evidence. As on the Divisional Court's conclusions, there is no requirement to do that. My Lord, FR is in Supplementary Authorities Bundle 2, tab 27, paragraph 60 and 73 to 74.
So sorry, which bundle?
It's tab 27,
Is
sorry,
that
volume
which
20, volume 28, in fact. Tab 27. And at paragraph 60, you can see what the court referring back to ZT Syria. The key points is that a reviewing court must consider how an appeal would be likely to fare before an adjudicator, and this is the same question that is before the Secretary of State, as the body responsible for deciding any appeal, and must assess the judgment which would or might be made by an adjudicator on appeal. It may become clear that the quality of the claim is such that the facts of the case admit of only one answer, but the process is essentially one of review. So this is the approach of the reviewing court, but it's addressing the question that the decision maker must ask, and you can see that again at paragraph 73 to 74. 1106 to 1107. At the top of 1107, there is almost common ground between the parties as to the test. It's whether an appeal would be bound to fail. In the language of the Secretary of State's guidance, the decision maker must be satisfied that the claim cannot on any legitimate view succeed. And then at 74, it's common ground that consideration of whether a claim is clearly unfounded will necessarily take into account the nature of what a claimant must prove in order to succeed. And then halfway through that paragraph, there must be careful consideration of the factual substance and detail of the claim put forward by the claimant and material relied by him or her in support, and the import of the body of objective evidence accumulated into relation to the state in question. In the words of Lord Hope in ZT Kosovo, the focus is on the quality of the claim. It's necessary to consider whether in the round the claim or some part of it is capable of belief. The Secretary of State must consider what approach would be taken by the first tier tribunal. In my submission, given that the appeal that an individual makes will cover all issues, general safety and individual matters, all relevant matters, it cannot possibly be right or fair to make that assessment, depriving the individual of the right of appeal, without giving that individual a chance to articulate what arguments, what arguments or evidence that individual relies on. And my lords, the Divisional Court, when analysing this question, looked only at the immigration rules 345C, referring back to 345 be, without taking into account this statutory context, applying Cooper and Wandsworth, which again, and the duty to supply the omission of the legislature, which again I won't ask you to look at, but it must be the case that in making that decision, at least the Secretary of State must give individuals an opportunity to comment on, to make representations on the issues, all the relevant issues in the appeal. And that cannot be done in 7 days. Now, my lords, in my submission, it is so clear from all these arguments that fairness requires an effective opportunity for those at risk of removal to make representations on general safety. But in my submission, a sensible argument cannot be made to the contrary, because the question is so critical. It is obvious that relevant issues are matters that individuals should be able to make representations on, and they were highly relevant in this context. They led to quashings. And that is why, as we've explained in the skeleton, until the second day of the hearing, the Secretary of State accepted that this was what the common law required. And my lords, that's paragraphs 4 to 6 of our skeleton argument. It wasn't a casual acceptance. It was implicit in the paragraphs of the detailed grounds of defence that I've shown you, paragraphs 5 to 1 to 2. That's Common Bundle 2, page 316. And it was made explicit in a post-hearing note submitted by the Secretary of State after the September hearing in the linked claims. And that is in the Common Bundle, tab 4, it's volume 14, unique number, page 154 to 158.
Sorry, which bundle? Common bundle.
Common Bundle 1. Sorry, it's Core Bundle Asylum Aid, volume, unique number 14. And it's the tab 15, page 154. And it's paragraph 7.3.
Sorry, I was just checking something. Which bundle are we in?
We are in AA Core Appeal Bundle.
What's
so
the unique
volume 14, tab 15.
Yep, got it,
There
thanks.
isn't a tab 15 in my AA core, it only goes up to 8 sub 4. And page 154 doesn't have any paragraph.
This is what I'm looking for.
My page 154 is a completely different document.
Could it be that we're not talking about the same bundle? It's
Could be.
Asylum Aid Core Bundle.
Yeah, I've got that.
And it should have all the pleadings in it.
It's got your appellant's notice, statement of facts and grounds, copy of the decision of challenge. Is that it?
Yes, well, there should be a section B after tab 8, which has got the skeletons in the High Court. But if you
I
don't,
expect my JA will send it. Who's just sent it? Thank you.
Sorry,
so
I've now lost the page. Which?
it's at 155. So 155, the Secretary of State looks at Balajigari, paragraph 3 onwards. Having summarised paragraph 2, I should say, the essence of the obligations that the Secretary of State draws from Balajigari and Citizens UK. This is on page 154. And then at paragraph 5, these criteria, that's the criteria in the Act, the 2004 Act, in the immigration rules, and in the 2022 Act, this is at paragraph 4. These criteria in all those statutory materials and in immigration rules do not involve an allegation of dishonesty or any other serious allegation going to a person's character. Instead, the criteria simply require a connection to a safe third country and assess the safety of the country to which they are to be removed, both generally and for the particular claimant. Nevertheless, given the significance of the decision for the claimant, the Secretary of State accepts that procedural fairness requires in this context that the claimant be informed of the gist of the decision she is considering making, as set out in 7 below, so she has an opportunity to make representations. And then there is a caveat about other immigration decisions or contexts. As to what, this is at paragraph 7, procedural fairness requires in this context, the obligation to provide the gist means that the Secretary of State should inform the claimant of and allow him or her an opportunity to make representations on the following matters. The Secretary of State is considering whether the claimant was previously present in or had a connection to one or more safe third states and what the name of each such state was. The Secretary of State is considering whether to declare the asylum claim inadmissible and to remove the claimant to Rwanda. The Secretary of State considers that Rwanda is a safe country. And then the Secretary of State will consider whether there is any specific reason specific to the claimant why Rwanda would not be a safe third country in the individual circumstances of the claimant. So it was 7.3 that the Divisional Court then expressed doubts about. My Lord, I mentioned that this wasn't a casual acceptance. This note was produced after a hearing in September in which the Secretary of State had asked for permission. My learned friend Lord Panic had asked for permission to set out their stance on the common law in answer to questions that were put to Mr. Brown, KC, by the court. And so that note was the considered position of the Secretary of State.
Could you just read paragraph 8 as well, please?
The Secretary of State should then consider any representations made and or individual circumstances before deciding whether the asylum claim is inadmissible, and if so, whether to remove the claimant to Rwanda.
Thank you.
And but despite that, and despite the fact that this argument was repeated in the Secretary of State's skeleton argument,
Yes.
and that is in the core bundle at paragraph 62.3, sorry, in the core bundle of asylum aid, which is at is volume 14 at 105, page 124 in particular. Paragraph 623, the court asks the Secretary of State to reconsider what the common position, what the common law required. And my Lord, it's paragraphs 501 to 502 of this supplementary bundle, and I do suggest that we look at that, my Lord. It's tab 15.
Of which numbered bundle, please?
Tab 15 of the supplementary bundle in asylum aid's case. Sorry, it's volume 15.
15, yeah.
It's the supplementary bundle in asylum aid's case.
And pages again, please.
And it's 501 to 502. So 500, sorry, 500. And you can see in the middle of that page, see well, actually a B, Mr. Justice Swift. I mean, just to state something obvious, Mr. Kilroy was saying yesterday, how can 7 days be good enough, even with the possibility of the extension, if you have to go through all this stuff? Yes, the Rwanda material and the way in which you concede that case, well, you know, given there is a mountain of matters to consider before you can make representations, no one would say that 7 days is a good starting point. You would have a longer period plus the possibility of extension. Now, if that is right, you can see where the attack to the 7-day period comes from. And then over the page is where the Secretary of State withdraws her position on 62.3. At 499, there is further reference, my Lord, throughout that page to.
Sorry,
62.
I thought we were on 500 in back.
I'm just referring back without asking you to read it all at this point, but for your note, I do ask you to read these pages, 499 502. It's the suggestion that it concedes the claimant's case, asylum aid's case. And you can also see at 499E, again, reference to what it was that I said needed to be disclosed, which is the CPIN, the note for balance CPINs. And I emphasise it was at no point asylum aid's case that the entirety of the material before these courts had to be disclosed in advance of the decision. That was not what asylum aid said at all. In my respectful submission, the law is clear. That's why the Secretary of State took the position that she did. She reversed the position over the lunch adjournment on the second day of the hearing. It's not a position that has been taken as a result of a settled position on the facts being reached because of a generic judgment. It is a point of principle. And as a point of principle, it cannot be defended for all the reasons that I've set out by reference to the case law we've been looking at. And in my submission, if asylum aid succeed on ground one, then they succeed and we succeed on the entire case, because at 420 to 421 of the judgment, the court makes clear that its whole reasoning in rejecting asylum aid's case depends on its conclusion on general safety. And you can see that this is in the judgment for bundle 1 at page 142.
Sorry, you asked us to go there.
I'm
Well,
just
I'm
conscious of
I'm
time.
concerned. You've got 11 and a half minutes left, and you've 5 more grounds. I think. I've got the.
I think I have till 12 o'clock.
Oh, do you forgive me then? Even so, it's quite tight, Mr.
It is
Gilroy.
yes.
So,
So I'm not going to ask you to look at it, but if you could, for your note, 420 to 421
Well, of what? Sorry.
of the judgment,
Oh yeah.
bundle 1.
Yeah.
And the court makes clear that the entirety of its rejection of asylum aid's case is based on its conclusion that it's not necessary to make representations on general safety. My lords, can I now turn to grounds 2 to 6? Before I do, I need to correct a misrepresentation in the judgment of asylum aid's position at 394, which states that asylum aid's submissions on 7 days being insufficient rested on the premise that fairness required an opportunity to make representations on Rwanda's general safety. And that is not correct. That's at 394 of the judgment. Asylum aid's position, it made clear, insofar as it was possible to do so after the Secretary of State's turnaround.
Sorry, I don't want to slow you up, but I haven't found the passage you're saying should be correct. I've got J394.
You can see in the middle the claimant's
Yes.
sanctuaries that in no case could 7 days be a permissible period within which to require representations to be made, and B, that effective representations could be made only with the assistance of a lawyer. Both rested on the premise of the duty to act fairly.
Precisely, got it.
Yes. And that's not correct. Once the Secretary of State had reversed her position on the law, the asylum aid made clear that it maintained, even if that were correct as a matter of law, there was still not enough time to do what needed to be done.
so is it a time argument, really?
Yes.
When one boils down to it, when one boils it down.
Yes, my lord.
Yes.
Asylum aid
So the note you showed us a moment ago, which the Secretary of State apparently accepts that it's entirely possible for somebody to make representations that she, the Secretary of State, is wrong in her conclusion that Rwanda is safe.
Yes.
So that's the principled point, and really your complaint is that if I've got it straight, is that the Divisional Court went a good deal beyond it. That's your submission. But the core submission is that 7 days can never be enough.
Yes.
Yeah.
Is it
Well,
that it can
well,
never be enough, or that it will often not be enough?
Well, my lords, in the context of this scheme, and I do apologise, I've taken it very fast, and because I have
Don't
so
worry.
little time. But at the back of our skeleton argument, there are the 6 decisions that need to be taken. It's in the annex in every case.
I've sawn that.
Yes.
Can I just ask one question about that,
Yes.
which has slightly puzzled me? I haven't seen a separate question, but the questions appear to be focused, the 354B questions seem to be focused entirely on the question of safety. But the Secretary of State appears to say that in every case, a decision will be made about whether it is appropriate to remove this particular applicant to Rwanda under the scheme. And the language of appropriateness goes beyond, as I've understood it, maybe more a question for the Secretary of State, the question of whether Rwanda is safe in 345B terms, maybe wider considerations. Have I misunderstood? Or
Well, my lords, there are the 6 questions or 6 decisions that we've set out in the annex include inadmissibility.
yeah,
And my lord, those.
no, I've seen them and I've been,
Yes, so-
I
as
have
part
been
of
through
that,
them.
this-
There isn't a question.
About
Is Rwanda appropriate for the individual?
no, well, my lord, as I understand it, there isn't a further question asked by the Secretary of State. Although obviously she always has a discretion to ask and answer that question.
Okay, well, I'm not going to spend time with your precious
Yes.
time exploring that, but I want to find out from someone what sort of things are covered by appropriateness that aren't covered by safety.
Yeah. My lords, I should just say on my time, and those behind me have pointed out, I did lose 15 minutes.
Yes, so it's
yesterday.
12.
So it's 12:15, in fact. I was 1 hour. I was allocated 2 hours.
Forgive me. I was overlooking the fact that Mr. Hussein had given up a quarter of an hour of his reply.
So I was hoping to finish by 12. But I don't
Oddly,
think I
you
will.
were allocated
Yes.
1 hour and 59.
59 minutes, yes.
So
But
that's,
I've said 2 hours,
that's
but
a bit odd.
Yes.
Let's not spend
I
even
was
a
there
minute
just to
exploring
tease.
how that came about. I'm sorry if I've alarmed you,
Well-
Miss Kilroy. It's my forgetting that. Yes.
but nonetheless, I think that's a question for my learned friend.
Yes.
Yes.
But whether or not that question has to be answered, it's an incredibly complex system of decision making, and evidence is relevant, as we explain in that annex. And I do not have time to go through it, but I do invite your lordships to read it together with the Divisional Court skeleton that Asylum A submitted, which was part of our essential reading. The Divisional Court skeleton, it's in the core bundle, but we also handed a version up which has corrected page references to the bundles before your lordship, which you should have separately. And we've got hard copies here if they haven't made their way to you.
Thank you.
So, my lords, I do. It is necessary in my respectful submission, given how short time has been, for your lordships to read both skeleton arguments, including the annexes. But it is my submission, when you look at the complexity of the decision-making scheme, that it is not possible to decide any case fairly within 7 days. Now, I don't need to put it that high in order to succeed, but I do put it that high on the evidence that was before the Divisional Court. And that is why, and the court accepted that evidence, effectively, when it asked the Secretary of State to reverse, or suggested that the Secretary of State reverse her position, because otherwise she was conceding the claim. And my lords, so I do say that in this case. And my lord, it is important to note that the Secretary of State, in her skeleton argument below, could only identify one situation in which the standard timescale would be sufficient, and that was when an individual did not want to make representation. And I will turn up the reference to that in a moment, but that is my submission on the 7 days. And it is a time...
I'm sorry, I don't want to hold you up, but I am puzzled by that. No circumstances where 7 days would be enough? If you wanted to make very straightforward representations, you might say, I'm a victim of torture, I already have a report showing, I don't have to get it, I have it already. It would always be the case, but it might be the case for particular reasons. And I don't believe that the authorities in Rwanda are able to cope with someone with my condition as a result of being a victim of torture. Why can't you put that in 7 days if you have it already?
Well, my lord, because the scheme is based, and you can see that in all the evidence that was before the court, and it's described that way in the judgment, on people having just arrived in this country. So the whole scheme is, and the judgment records this, is that people
I see, your point is you will always have just arrived. This won't be a typical case where you may have been in detention for a while.
No, this is a scheme for people who've just come off small boats. That's what it's designed for. That's where the dangerous journeys, which is decision 4, comes in. It's paragraph 33 of the skeleton where the Secretary of State identifies a case where someone doesn't want to make representations as the example of when 7 days would be sufficient. Except if you don't want to make...
Well, suppose you wanted to say, perhaps I made the torture example too difficult. Suppose you want to say, I have 3 brothers living in Birmingham, and it's very unfair that I should have to go back to Rwanda. Now, there might be a reason why the Secretary of State says that isn't enough. But it's certainly the argument you might want to put.
Well,
do you need more than 7 days to do that?
I think at this point, that goes... Can I come on to ground 2? Because when we look at ground 2, you can see from the decisions that are being taken that the Secretary of State requires evidence. And if I could ask you to look at the approach that is taken in these decisions, you can see why it is necessary to provide evidence. It's in bundle 7, which we were just in. Tab 20, volume 2 of the AAA call. Page 675 to 7. And you can see, my lords, under the heading evidence, no further evidence has been provided. This is at paragraph 18. Then at 26,
so no further evidence of what?
So that you don't. There is a summary of the basis of the claim. So they've summarised the evidence,
Yes.
and there isn't any. I mean, there is a letter of the 27th of May at paragraph 9.
Mm-hmm. Isn't a letter evidence?
It's representations, my lord. It's not evidence. And that's not, but in any event, and you'll see at 16 to 17 that there is a complaint about time constraints. And then you'll see, I'm going to give you the paragraph numbers because of time, but I'll show you a couple. At 26, you failed to provide any evidence of your submissions as part of your submissions. 31, in the light of these circumstances, the Secretary of State has concluded that the claim advanced without any evidence does not come close to rebutting the presumption that Rwanda will treat you in compliance with the requirements of the Convention. And then it goes on at 42. There is no specified evidence to support an assertion you'd be left without support and destitute in Rwanda. And then at 59, you can see there is no evidence you were subject to exploitation and ill treatment. At 62, you've not demonstrated you're exceptionally vulnerable. 65, your representative has stated that you have as yet unassessed mental and physical health conditions as a result of traumatic experiences in your home country, and is further claimed that you present with symptoms of depression and PTSD. However, at this time, these claims are entirely speculative, and in view of other information provided by you, in no concern. So again, a lack of evidence. And the same at 81 on family and private life. You've not evidenced any reasons why you may face very significant obstacles to your integration. And it goes on, and all of the decision letters are like that, my lords. And the references are in our skeleton argument to numerous decision makers. The Secretary of State demands evidence of all the claims that are being made. And so, given that she demands evidence, in my respectful submission, she must provide enough time to produce it. And also, this is ground 2, people cannot realistically produce evidence without having an opportunity to access legal representation. These are people who don't speak English for the most part. They're lay people. And it's just to provide a period of time. It's not about necessarily herself facilitating access to legal advice, but she must give enough time to allow people to access it. And 7 days on the evidence before the Divisional Court, it's all set out in the Divisional Court skeleton argument, was not enough time. And that is why the court, in the end, concluded that it wasn't necessary to have access to lawyers. Implicit in that conclusion is that it wasn't possible to access for lawyers to prepare the necessary evidence in that timescale.
Well, it's not prepare, it's secure, isn't it? So, but what is your submission this, that we see the nature of the claim that was advanced in the letter we're looking at?
Yes.
Some of them relating to for example, medical
yes.
problems might be evidenced, I suppose, if quick access to a relevant doctor or professional were provided. But it couldn't be evidenced by medical records from a foreign country, for example, and many of the other things would, in the ordinary course, perhaps be supported by documentary evidence of some sort. Well, realistically, that's not going to be feasible, is it?
Not in 7 days, my lord.
Well, is it at all?
Oh, well, my lord, it is going... First of all, in relation to documentary evidence, people may be able to obtain materials from the country of origin. You can see that in the case of JB
Yes.
Jamaica
yes.
In the Court of Appeal, and they must be given an opportunity to do so if it's, if it's relevant. The whole point about this scheme is that it doesn't allow for that opportunity.
Also, I suppose, varies very much, but if you've been in a well-run facility in France or Italy, before you come and get on the boat, you may well be able to access medical records from there. You may or may not.
You may be able to access it from the health centre. The health centre. I mean, my lord, you have 2 interventions before you, as well as the evidence from asylum aid, which explain the importance of medical medico-legal reports in asylum claims and the need to access healthcare records, the Secretary of State won't accept them.
So I was just following up the factual
Yes,
question, which
yes.
my Lord put to you about, well, suppose you come from
Yes.
Eritrea or a remote part of Kurdish Iran. It's not realistic to say, oh, well, I need time to get my medical records from there, because you never will.
Well,
And I was just offering a suggestion that there might be an intermediate.
there may be other medical records, but in fact, people do on occasion obtain medical records from home. It's not,
This is one of the difficulties of dealing with questions entirely hypothetically, isn't it? That
well,
one can imagine all sorts of circumstances. Sometimes yes, sometimes no.
well, my lord, when people cannot obtain medical records, what happens instead is that they're assessed by professionals. If they come and they say, I've had a mental health condition, or I have developed one, then they are assessed by professionals. It's relevant to the question of whether they can be lawfully removed, and they must be given an opportunity to produce it. And under this current time scale, as the UN Special Rapporteur for Trafficking and also Freedom from Torture explained, but it's also in our evidence, it is not possible to go through the steps that are necessary to do that, alongside all the other tasks that need to be performed by a lawyer in that period of time, in that 7-day period of time. It's just, I mean, in my respectful submission, it's not very difficult to make that out. 7 calendar days from the point at which someone gets a notice of intent to the point at which they're told they have to put in all their evidence and all their representations is obviously too short. And the Divisional Court clearly agreed with that, which is why, at least on general safety, but in my respectful submission, it is implicit in their finding that you don't need to produce evidence, that they agreed it wasn't possible to produce it in that time frame. And it isn't. The evidence before this court and that court shows why. And my lord, before the, that's grounds, effectively, that's grounds 2 and 3 of Asylum Aid's appeal, which are in the skeleton argument at paragraphs 18 to 21 and 22 to 28. And you can see, summarised under 7 days, the range of issues that are likely to be relevant. So this is even if the scope is as narrow as the court has found. And the difficulty, evidence there, which I can't take you to, but I do ask your lordships to look at, about the difficulties in preparing that evidence in that time.
You don't have a positive case here as to how many days would be enough as a norm.
No, my lord, we don't. And we said below, and we say today, that it's not the function of Asylum Aid to select a positive case about how much time would be appropriate. And the Court of Appeal and Detention Action, when it found that this 7-day period of appeal in that case was too short, expressly stated that it wasn't for the court to suggest to the Secretary of State what time period would be appropriate, my lord. But it would have to be longer, significantly longer, in the light of all of the tasks that need to be performed. And my lord, it's my submission that my lord's judgment in the Supreme Court in A is to a similar effect. It's not the function of the court reviewing the lawfulness of a policy or a procedure to devise one itself. It's the function of the court to look at whether the one devised by the Secretary of State or any other government body is unlawful. That is where the limit is drawn. So, my lord, the Secretary of State had below and has today one real answer, only one answer, to the sufficiency of the time period. she produced no evidence below that the time period was sufficient in any case, and I've shown you the evidence and decisions table, which shows that it was impossible in practice for people to produce anything effective in that time period. And the answer she has is extensions. But, my Lord, the possibility of extensions is not an answer, in my respectful submission, to a standard time period, which is how the Secretary of State characterises it, which is unfair, even if I retreat from all cases, but in most cases that are likely to go through the system. And that's the test in detention action, which was adopted by the Supreme Court in A, which is you look at the full run of cases that go through the system. My Lord, for your Lordship's note, and my Lord, Lord Chief Justice will be obviously very familiar with it. It's tab 56 of bundle 21 at paragraph 67 that sets out the detention action test. Looking at the full run of cases that go through the system, page 2104, the standard time period is obviously unfair for that full run of cases. And I use the word standard time period because that's the language used by the Secretary of State. And it suggests that a standard case can be dealt with in 7 days. But a standard case is a case in which all the questions in that annex to our skeleton argument, decisions 1 to 6, have to be answered, and answered with evidence if the representations are to be effective on many of the decisions. Not all of them require evidence, but many of them do. So the possibility of an extension is not an answer, and that is particularly so because in practice the Secretary of State takes a very restrictive view of when extensions should be granted. And you can see that in the statement of Mr. McCaskill, which is in volume 15, supplementary bundle 288, paragraph 23.
What tab?
It's tab 15 as well.
Do you have a page number? Is this asylum aids and bundle?
It's asylum aids bundle, supplementary bundle.
Supplement.
It's paragraph 23, which is at page SB 288.
Could I have the bundle number again? I'm sorry.
15.
That's thank you.
Where individuals request an extension of time, and it should be said there is no policy suggesting extensions could be required or directing the basis on which they should be granted. This is the only evidence of that extensions are considered. Where individuals request an extension of time, these requests are considered on a case-by-case basis, taking into account the reasons requested for the extension, how long they've had to respond, their access to legal representation, and whether it would have been reasonable to have expected reasons to have been submitted prior to the request. There are no fixed criteria for an extension to be granted or refused. Factors weighing in favour of an extension of time include if someone has not had access to adequate legal advice, if they provide good reasons why they've not been able to make representations, brackets such as illness, trauma, or electronic communication failures. Factors weighing against include if they've had the opportunity to instruct legal representatives and chose not to do so. And then it says discretion has been used in most cases to extend the time period to respond to the NOI. If an extension is refused, further representations are generally considered. Now, my lords, there is an extensions table in the same volume which shows that in accordance with that restrictive approach, and I say it's restrictive because it obviously assumes that the standard time period will be sufficient in most cases, and it's only where someone has an exceptional or unexpected reason, like illness or trauma, for not being able to
Well, that's
comply.
not quite fair, is it?
Well, my lord,
That's one kind of reason.
well, no other kind of reason is given.
Well, someone has not had access to legal advice.
Well, again, but yes, not had access to legal advice is one. But what is not said is if they need to prepare medical evidence or if they need to prepare witness statements, it's assumed that the 7 days is sufficient for these purposes. And in fact, it's my submission that 7 days is obviously not enough if you need to prepare evidence as opposed to simply supply facts.
You were going to show us.
Yes, so the extensions table is at supplementary bundle 10, tab 2, so the same bundle, page 10. And these are a list, these are 21 examples. 10 of them are the claimants that were before the Divisional Court, 2 of which were stayed. And others were examples taken from the evidence before the Divisional Court, the asylum aids evidence. And it shows that very few, I can't take you through it all, but what it shows in summary is that very few extensions were granted and for short periods. So of 17 individuals or 17 requests for extensions of time, 5 were refused, 5 were not answered, and 8 were granted, but with relatively short periods of time. So we're talking a range of 7 to 19 days. And in my respectful submission, that is too short to produce the kind of evidence that is necessary.
Am I right in recalling that in the Refugee Legal Centre case, where the relevant time limit context was slightly different, but was very short, 72 hours,
Yes.
I think. The court held that system was not unlawful because of the possibility of extensions, provided that there were proper guidance given to caseworkers about the circumstances in which they should grant extensions to remove any suggestion that it should only be in exceptional cases. That's quite a close analogy, isn't it?
Well, my lord, yes
It's
and no.
in one way helpful to you and in one way not.
Well, in my submission, it's not unhelpful in any way, because in Refugee Legal Centre, which is not in the bundle, but is described in the detention action case.
Yes, I looked at it overnight.
There was a prior process of selecting people for the
Yes.
procedure, which was that their cases were straightforward, and straightforward meant did not require evidence.
Were thought by the
Secretary of State not to require evidence.
Right.
So the flexibility policy, and you can see this from proper reading of that authority, that the flexibility policy was for people who had been properly selected for fast track, but needed a bit more time within fast track. So in other words, it wasn't for people who were unsuitable full stop because they had complex cases or non-straightforward cases. It was flexibility for people who did have straightforward cases, but nonetheless needed more than the straitjacket of 3 days. That's the court's conclusion in Refugee Legal Centre. So here, the whole point about the asylum aids case below, articulated in the skeleton argument, is that this is a fast-track procedure that has been applied without any assessment of whether the people going into it have straightforward or complex cases. Everyone is funneled into it. The Secretary of State knows full well it's a complex process. It's brand new. It's subject to the kind of arguments that you've heard here. Even if it's upheld, there will then be monitoring issues. And there are numerous decisions that have to be taken, far more than the decisions in an ordinary asylum case, far more than the decisions in an ordinary safe country case. And so it is not possible to apply a procedure which is suitable for straightforward cases to cases which the Secretary of State knows full well are complex.
But what you do get,
Yes.
I take your point on that, is that, as I read it, it was effectively a condition of the declaration, that of the refusal of the claim,
Yes.
that there had to be a policy giving guidance, which, as you pointed out, there isn't here. We've only got what Mr. McCaskill says happens in practice.
Yes. You do get that from it. My Lord, my junior is pointing out that there is a description of how the fast track procedure works in one of the statements that is in the bundle at volume 15, AAA supplementary bundle, page 38, paragraph 76 to 78, or how it worked. Yes. And, but my Lord, so yes.
Sorry, page 76, is that right?
70.
I'm not asking, I just meant to I got the reference correctly.
Yep, it's page 38, paragraphs 76 to 78. And it was an explicit part of Asylum Aid's case to contrast this procedure with the fast tracks, because the fast track procedures had a whole range of safeguards. Flexibility is only one aspect of the safeguards that are necessary. Included the detention action case also had safeguards. But you didn't get into the appeal process that was considered in the Court of Appeal and Detention Action unless you had already been assessed as having a straightforward case. And notwithstanding that, the court found 7 days was not enough for the appeal. That was in circumstances where you'd had an opportunity to make representations before the decision with the assistance of lawyers. Still 7 days wasn't enough. That's detention action in the Court of Appeal, my Lord, which is in the bundle at tab 25. This is volume 2. I'm not going to turn it up, but my Lord, these fast track procedures are quite different because they have within them a whole range of safeguards. And it's, as I say, without wanting to repeat myself too often, the distinguishing feature of this scheme is that the Secretary of State applied a highly abbreviated process to a decision-making set of decisions that were inherently complex, without any assessment of whether it was appropriate to do so either generally or in individual cases. My Lord, because of time, I'm going to move on. All those references to all those authorities are in both skeleton arguments, the one below and the one before your lordships. And I do apologise to take it very fast, but has always been Asylum Aid's position that in order to properly explain this case, it does require quite a lot of time. And so, but as a substitute, I do ask your lordships to read those skeleton arguments with the references, if possible. So ground 4, disclosure of provisional conclusions. Just again, because of time, following my skeleton argument very closely. Paragraph 27. The court is wrong to conclude that even if the scope of the procedural obligation is limited, as they found, that the common law doesn't require individuals to have access to provisional conclusions. And my Lord, the case law is set out there. I don't think I need to go through it again. Because the court did not give any proper reasons for concluding that in this scheme people did not need to have access to some idea of what the Secretary of State's position was, the reasons for it, as opposed to the blank position, before being able to respond properly. And my Lord, the materials, the CPIN, the MOU and the note for BAL, as I've already shown you, were relevant, not just to general submissions, general matters, but also individual matters. and it wasn't possible to properly target representations without seeing them. And equally, the conclusion that an individual's claim was inadmissible often rested on assessments derived from the screening interview, would always, in fact, derive from assessments at the screening interview. That was what caused the Secretary of State to funnel individuals into the inadmissibility and Rwanda scheme in the first place. But the Secretary of State did not disclose what those reasons were, so individuals did not have an opportunity to address them in their cases. And you can see some of the consequences of that in NSK's case, and the reference is in the judgment, to the judgment in paragraph 28. So coming now to access to justice. My Lord, on this, I need to correct again the judgment, which suggested that that asylum aid had conceded that its access to court submission would fail if the court found against it on procedural fairness. My Lord, that is not an accurate representation of asylum aid's position, because it is based on the position asylum aid took when it was common ground between the parties that fairness required an opportunity to make submissions on all the issues, including general safety. And asylum aid did accept that if the court found that there had been an adequate opportunity to make submissions on general safety prior to the decision, then 5 working days would be sufficient to deal with would be lawful to deal with a challenge to that after the decision. But that was the full extent of asylum aid's acceptance. And once the court reached the conclusion after the hearing on an issue that had not been pleaded by the Secretary of State, that it was not necessary to provide an opportunity on general matters, then, as we explain in paragraphs 29 onwards of the skeleton argument to 33, that the case on access to court became even stronger. Because what it meant was that for the first time, after the decision was received, individuals would have to deal with all the matters that were relevant to the decision to remove. Prepare all of that evidence, including evidence about their personal circumstances, and lodge a judicial review, and seek an injunction in order to prevent their removal. And my Lord, may I, paragraph 32, there are references to ex parte polemics and also to FB, which your Lordship will recall, my Lord Chief Justice. At paragraphs 92 to 94, we obviously can't turn them up.
Just the bundle number and
the bundle number is 28, and the bundle number is at the end of paragraph 32.
Right.
It should say 28 if you've got the unique numbers. And what the court made plain in that case is that it was necessary to have effective and real rights, which is the point I opened with, in access to justice as well in the real world, and that must be a real opportunity to stop the removal, so that the access has to give you an opportunity to stop it, which must include being able to produce the evidence that is relevant to the test that the court applies, whether on the strength of the claim or on balance of convenience. And we've given references there to the decisions that were taken by the courts on interim relief at paragraph 20, footnote 22, which showed that people were simply not in a position to produce the relevant evidence that would have succeeded in, that might have succeeded in showing that the removal should not proceed. And my Lord, of course, all those individuals who might have been removed, did not obtain injunctions, but then later, as a result of the European Court of Human Rights' injunction, did stay in Rule 39 indication, did end up staying in this country. All of those decisions have now been quashed. They are not subject; those quashings are not subject to appeal. So the position must be that those individuals would have had to have been brought back under their agreement. So, my Lord, in my submission, when you look at what has occurred in these cases, people were plainly not in a position. Yes, they could get into court, but they could not prepare their cases properly. My Lord, finally, turning to ground 6, because of time, I'm going to ask you to rely on the submissions in the skeleton argument, but also add into the mix that the court did not construe the rules in paragraph 17 alongside paragraph 19c, which I took you to earlier on. That was part of the statutory context. And it obviously affected, if you were going to construe the whole context, what fairness required, because of that forward-looking exercise that is required on a certification decision. And finally, at paragraph 39, the asylum aid submits that its appeal should be allowed because, and its claim as pleaded, evidence argued at the hearing should therefore have been allowed because there was the simple basis for refusing it. For all the reasons I've explained, that was wrong. There is now a respondent's notice, but I will deal with that in reply.
Thank you.
Unless there's anything more.
Yeah. Thank you very much indeed, Ms. Kilroy. Mr. McCulloch, I think 4 minutes later than billed, but Ms. Kilroy has worked wonders in deploying her submissions.
She has, my lord.
So you have about an hour. If you're able to shave 4 minutes off it, that would be for the benefit of many of those sitting around you. But obviously you can have your hour if you want it.
My lord, I'm grateful, and UNHCR is grateful to the court for submitting both this information and all submissions. The court has our detailed written submissions. In addition, you have our written observations below before the Divisional Court, and we would respectfully ask that those are read in detail. There is very little overlap between the submissions before the Divisional Court and this court, with the exception of our observations in relation to Article 31, where I acknowledge this could be overlap. But it is, with respect, important for the court to see the way in which UNHCR was formulating its observations and concerns before the Divisional Court as a backdrop to our submissions. The court also has, I'm well aware, the 3 witness statements from Mr. Botanic, who, for these purposes, articulates the High Commissioner's institutional evidence, views, concerns. I emphasise they're not his personal views. He is the mouthpiece for the institution. Mr. Davinsky and I will be dividing our time so that I address, in a really, I apologise in advance, whistle-stop fashion, the weight properly to be given to UNHCR's evidence, because we do, with respect, take issue with the Divisional Court's formulation and treatment of that evidence. And she will be taking up most of our time by focusing on the position in principle as concerns assurances and on specific identified defects in the Rwandan asylum processing system, which persist notwithstanding those assurances. And she will also make brief submissions addressing Article 31. Now, my lords, in order to try to accelerate this process, we have prepared, as
we did below, a list of references, which I hope will save considerable time. I wonder if that could be handed up, which provides what might be characterised as a road map, but also a, I hope, convenient list of the references that,
Can it be sent electronically, please?
of course. On seeing that document, I hope the court does not view it with too much alarm. We are very alert to the need not to traverse ground that was traversed by Mr. Hussain yesterday. So we, for reasons of time and the efficient use of the court's time, will not be covering all of those matters. That could have done with more time and without the ground having been travelled previously. Before I turn to the substance of my part, could I pick up very briefly a point or a question raised by my Lord the Master of the Rolls yesterday, a query in relation to the Israel-Rwanda transfer agreement, and the question as to the judgment of the Supreme Court in Israel. As Mr. Hussain said, that judgment is not before this court. It wasn't before the Divisional Court, and there's no indication that it was considered by the Secretary of State. On that basis, the judgment may not have any significance for the purposes of the legal issues in this case.
Have you found it, Mr. McCulloch?
Well, my lord, that's what I wanted to, because there's not a straightforward answer to that. The short answer is no, in that we don't believe, or my clients don't believe, they have accessed an English version of the judgment.
Have you found it in any version?
We haven't found any official translated version, nor any certified translated version. A copy of a translation of a judgment, and we think there may be more than one Israeli Supreme Court judgment, but we do have a copy of an unauthorized, uncertified translation.
It may be that your researchers and ours have followed the same path,
Right.
Hopping through the links. But anyway, it'd be helpful to see that.
Well, with those caveats, of course, to cut to the chase, as it were, with the qualifications in relation to the document, it does provide an indication, and when the court sees it, paragraph 87, the end of paragraph 87, which is a long passage, gives an indication of the nature of the assurances in broad terms in that case, which, without holding everyone in suspense, do confirm what's described in this translation, caveated as it is, an explicit undertaking of what's described as the third country we all know now, Rwanda, which deportees will enjoy human rights and freedoms, and that the principle of non-refoulement shall be complied with. In addition, the agreement refers to the ability of deportees to file a request for asylum and to enjoy the status of a refugee insofar as their application is approved. I re-emphasise UNHCR has not seen a copy of the assurances themselves or the underlying agreement. My Lords, with four rather disparate preliminary observations. First, the nature of UNHCR's evidence. Your Lordships will be aware that in accordance with the Divisional Court's directions, UNHCR has addressed the position as at July 2022, and we were specifically refused permission to submit any updating evidence. So it is important to appreciate that that is the time that is being addressed. And that evidence draws on UNHCR's lengthy first-hand experience in Rwanda, of which the court will have clearly gathered. And Mr. Botnick articulates the carefully reviewed and considered institutional view of UNHCR, drawing both on its experience generally in relation to the Convention and refugee asylum processing standards, but also its specific experience in Rwanda. Secondly, context. The Secretary of State emphasises that the weight to be attached to UNHCR's evidence in any case depends on the context. We agree, although differ clearly, and this will be a point I return to, as to what the relevant elements of the context are. But we agree subject to a recognition of the intrinsic features that apply to UNHCR, in particular its global presence, authority, and mandate, including the entirely non-political character of its work that's enshrined in its statute. And that's our observations at paragraph 16, paragraph 6. So I'll return in a moment to
So
highlight...
when you give reference to your observations, that your observations below.
The observations here. This court. Third preliminary observation, good faith. UNHCR does not generally comment on the good faith of states with which it works in entering into agreements or arrangements by those states. The reasons for that are explained at paragraphs 5 and 6 of LB2. And those paragraphs are, with respect, quite important both for this point, but also more generally in explaining the nature of the evidence and where it lacks specificity in some respects, why that specificity is lacking. There are, as the court will, I'm sure, well appreciate, sensitivities in relation to UNHCR's role and mandate and function.
Well, they're operating in a diplomatic environment and need to be diplomatic.
My lord, exactly. But for present purposes, the specific and detailed concerns which UNHCR has articulated in relation to the processes to which those who would be transferred under this agreement with the United Kingdom apply even assuming that the government of Rwanda has entered into the Memorandum of Understanding in good faith and with a genuine intention to honour the commitments it has entered into. So it is not a part, and certainly not a necessary part, of UNHCR's concerns to impute any bad faith to the government of Rwanda. We're simply, we don't go there, to put it colloquially. We don't express any view at all about good faith, but those concerns persist even assuming good faith, good intentions. Fourthly, the unequivocal warning. This is a case in which UNHCR has unequivocally indicated that there should be no transfer of asylum seekers under this policy because of its clear view that the arrangement is incompatible with the UK's fundamental obligations under the Refugee Convention. That is a relatively rare step for UNHCR to take, and not one which is taken lightly. The court will be familiar with the Dublin cases, in which for Greece there was an unequivocal warning by the time the well-known case of MSS came before the Strasbourg court. In Italy, there was never an unequivocal warning. And for Bulgaria, there was an unequivocal warning in 2014, which was subsequently lifted. All of the judgments that we refer to at paragraph 17 of our written observations reflect the particular significance of whether such a warning was or was not given by UNHCR for what we submitted is very good reason. And that's also referenced in paragraph, those reasons and the rationale are referenced in paragraph 19 of our written observations before this court. Turning to weight. First submission, UNHCR's expertise has been recognised by the UK government in the course of evaluating Rwanda as a potential destination for those seeking asylum in the UK. Now, I think they're the only documents that I'm proposing to refer to, but I wonder if the court could turn up in volume 4 of the Common Bundle. Tab 49, page 1209. That doesn't have much of a, by way of context, headed official sensitive discussion. We know from the index that it's a note to the Home Secretary dated the 3rd of March 2022. And turning on to page 1209, so just to put this in context chronologically, the court will appreciate this is at a stage in which Rwanda was under consideration before the MOU had been signed and was announced in mid-April, 13th and 14th of April. Page 1209, paragraph 12, there's consideration, bottom page 128 is the heading, Public Parliamentary and Stakeholder Handling, reference to UNHCR at paragraph 12, in the context of consideration of engagement with what they call stakeholders, and a concern, it appears, that engagement with the UNHCR, last sentence paragraph 12, will give them more time to organise their campaign against these measures when they're announced. But there seems to be some tactical
well, you need to look at the context. It's the UNHCR was lobbying against any such arrangements, irrespective of
absolutely, and
fact.
Expressed as in the middle of that paragraph, real concerns about the Australian model.
Yes.
And then page 1211, the box at the top of a list of organisations in which it was contemplated there should be discussions, a reference to the undoubted expertise and experience of managing part of the refugee process, as well as knowledge of the system more generally in country X, useful to compare and contrast their assessment of the country X asylum system with that of the government. So recognition both of the authority and experience and the need to cross-check what is being indicated to the UK by the Rwandan government. And then, last document, page 1212. We do have a date on this, 8th of March, an email, and it very much mirrors, I didn't refer specifically, but mirrors the points in the previous note to the Home Secretary. Again, it can be seen from the first bullet point that it's contemplated that UNHCR should be consulted, that ministerial clearance is required.
I'm so sorry, Mr. McCulloch, I've not caught up with the page.
I'm sorry, 1212. It's just the
I'm
first
sorry.
page of the next tab.
Yes, I've got you.
And if I could just ask the court to read, for current purposes at least, first, second, sixth, and eighth, bullets 6 and 8, and then the penultimate one on the page.
Yes.
Now, of course, UNHCR was in fact never consulted before the agreement was finalised. And we do, with respect, find it curious that the Secretary of State now suggests that UNHCR's evidence is of minimal significance. And one of the reasons that they say it's of minimal significance is that UNHCR is not involved in the formulation of the assurances and within the agreement. And that's in a situation in which such involvement was contemplated. The significance and authority of UNHCR in that process was recognised at the time. But for whatever reason, and I don't think it's articulated, we've seen the hint that there was a concern that they would be hostile to it or would not think it's a good idea, that was not pursued. My Lord, as far as the legal position is concerned, I hope that it circumscribes UNHCR's position to advance 4 propositions. Then I think I'm actually going to have to sit down because there's a lot more I'd like to say, but I'm eating into Mr. Binsky's time, and the detail is important in relation to the assurance, into the evidence and the assurances. First, it is recognised by UNHCR that there is no legal presumption that UNHCR's views should be regarded as decisive or binding, and ordinary principles of evidence apply to UNHCR's evidence. Secondly, that concession, which is made on the basis of legal authority that is binding on this court, does not entail the conclusion that UNHCR's views and evidence do not attract any special regard. There are 2 negatives there. It doesn't follow that UNHCR's views and evidence shouldn't be regarded as special. Third, on the contrary, the authorities confirm the special regard that should be accorded to UNHCR's evidence in the context of matters within its expertise and remit. And we submit that patently applies to its evidence in this case. And in such contexts, the evidence of UNHCR may be preeminent and possibly decisive, to use the words flagged up in EM Eritrea, which were derived from the Strasbourg case of MSS.
Which case?
MSS. So the EM Eritrea, paragraph 70 to 74 was a key passage.
Yes.
And they take that formulation from below, from Strasbourg. Fourth, the Divisional Court was wrong, we respectfully submit, to hold at paragraph 71 of the judgment that the views of UNHCR in this case no special regard. And that error may be seen to have contributed to its failure to address most of the central aspects of UNHCR's evidence in this case.
15 matters.
15 matters. My lords, I would have a lot more to say. I don't have time to say it. You have the references, the key cases in our submission, Riem Eritrea. Helpfully following that, Tabriza, which resolves what might otherwise be seen to be a tension within Lord Kerr's formulation in
Could you remind me how to spell that so my note is at least coherent?
it's in the list, but it's Tabriza, T-A-B-R-I-Z-A-G-H.
Thank you.
In which my Lord the Vice President
Yes.
resolved that what was advanced by way of focus on the no more, no less at the end of Lord Kerr's passage in the Eritrea. And by way of context, the cases relied upon by the Divisional Court and the Secretary of State, HF Iraq and AS Afghanistan, there on the list, are of an entirely different context. They involve conditions on return to a country and the humanitarian state that they would, humanitarian conditions that they would propose. They have nothing to do with asylum processing, different context. Furthermore, there was what's described in HF Iraq as a raft of other material, and it was recognised by Lord Justice Elias that the position is very different if the only evidence in a case is from UNHCR. So context is all important. None of the features which the Secretary of State rely upon in our submission undermine or diminish the weight which should be attributed to UNHCR's evidence. And 4 headlines that I simply give from those we highlighted, paragraphs 16 and 19 of our submissions. Firstly, the novelty for the United Kingdom. The Secretary of State suggests, well, because it's a novel process, then UNHCR doesn't really have much to add because they've never experienced it before. We respectfully submit that quite the contrary conclusion applies. Because it's novel, it needs to be regarded all the more carefully by reference to what has gone on historically. Mr. Dubinsky returned to that. Secondly, the assessment involves consideration of safeguards and standards required for determination of refugee status, core to the UNHCR's functions. Thirdly, the conditions and procedures in fact operated on the ground are of particular significance in assessment how the novel arrangement would be likely to operate in practice. Fourthly, the precedent for Rwanda. Although unprecedented in the UK, the government of Rwanda has previously entered into a transfer agreement with a foreign state, Israel. And what's known of that is Mr. Hussein submitted yesterday in our submission of particular significance in any assessment of the new UK-Rwanda arrangement. And fourthly, discrepancies. Mr. Hussein highlighted various instances where the government of Rwanda has asserted to the UK government matters which appear to be reliably contradicted in UNHCR's evidence to the court. And yet those contradictions simply aren't addressed by the Divisional Court or really any reasoned response from the Secretary of State either. So, my lords, I'm sorry, that's a very truncated submission, even so it's gone on longer than I hoped and intended. I'll hand over to Mr. Binsky.
Mr. Binsky.
My lords, with inopportune timing, the court hearing loop is not working today, so I should be able to manage with ordinary hearing aids, but I apologise in advance if I have to ask for repetition of any questions.
Right, well, I'm very sorry about that.
I shall address you first, as Mr. McCullough said, on whether the assurances in this case suffice to avert real risks of refoulement and other serious harm, and how that was approached by the Divisional Court, and then, time permitting, Article 31. And I'm now at paragraph 4 of our list of references. UNHCR's assessment is that Rwanda's RSD process is marked by acute unfairness and arbitrariness, some of which is structurally inbuilt, which gives rise to serious risks of refoulement. The Divisional Court reached or articulated no conclusions as to key points in the case arising out of UNHCR's evidence. To give 5 examples, there are no conclusions in the judgment concerning the overall adequacy, reliability, or fairness of Rwanda's current RSD system, or as to whether incidents of refoulement are occurring thereunder, or whether the government of Rwanda understands its obligations under the assurances, in particular the prohibition of refoulement, whether the government of Rwanda has been responsive to formal warnings from UNHCR in the recent past that it has breached or is about to breach that prohibition, a matter which is of considerable significance given Rwanda's duty under Article 35 of the Refugee Convention to comply with UNHCR, and finally, whether serious abuses occurred in Rwanda's earlier third country transfer agreement with Israel. And moreover, save us to Israel Rwanda, which I shall come back to, the Divisional Court, if it considered those matters relevant, gave no reasons why, I should say. So unless those matters are irrelevant, we do respectfully say that the Divisional Court's judgment cannot stand. And indeed, that's all the more so, I would add, if the Divisional Court was purporting to make, as my Lord, the Lord Chief Justice put it during the asylum aid submission, a judgment of a country guidance type. So the critical question as to safety before this court, we do say, is whether the flaws and risk in Rwanda's current system and the abuses that have occurred thereunder are relevant or not. The Secretary of State's position is that the assurances wipe Rwanda's slate clean. This is, and I am now in the note at paragraph 5, or the references list. She asserts that evidence of current or past problems and abuses is of limited or even no relevance because the events described by UNHCR did not occur under the MEDP. She is constrained to take that position, it appears, because of the concerning nature of the evidence and because of the approach she herself took to it. And she's moreover constrained before this court to maintain that position owing to the approach taken by the Divisional Court. UNHCR considers the clean slate approach to be doubly impermissible, wrong as a matter of general legal principle, and a fortiori impermissible on the facts of this case. And I shall take the facts first, if I may. This is now paragraph 6 of the references note. There is no clean slate here, and I'm using that as a sort of shorthand on the facts, because the system under the MEDP is not, in important respects, new. The Rwandan government insists that the process is already in operation. This is not a new process. It's an adaptive model. And it is indeed correct that the adaptations proposed under the MEDP do not change the aspects of the current system. There are repeated references in the MOU and in the note verbal to Rwandan standards and laws. There is no intention to depart from those. They are a thread woven through the assurances. And I shall focus on 3 examples here of specific ways in which the key features of the current Rwandan asylum system are maintained. The first, and I'm now at 6A of the references list, and I apologise, I'm going to go at quite a brisk pace rather than not ask you to turn up documents, but simply give you the references here. First is the role of the DGIE. And this is important for a number of reasons. Now I'm now at Roman numeral 1 of 6A in the references. The DGIE is implicated in each of the categories of refoulement and associated abuses in UNHCR's evidence. Under the Israel-Rwanda agreement, the DGIE's actions reported in UNHCR's evidence included removing transferees' documents at the airport, arbitrarily detaining them before those transferees were taken against their will, sometimes over land, sometimes by air, to Uganda, a country where they had no right to reside, so that chain refoulement was a foreseeable result, and indeed, in some instances, occurred. And I would add parenthetically, in light of some of the questions yesterday from the bench, that UNHCR's evidence, you have the references here, shows that some of these transferees were moved on from Uganda to Kenya, where they were imprisoned for illegal entry. Kenya was then about to refoul them to their country of origin, Eritrea. UNHCR managed to intervene and stop that. Coming back to the DGIE's role in Israel-Rwanda, the DGIE itself made random visits to transferees in their accommodation overnight. Mr. Hussein read to you yesterday from parts of UNHCR's evidence relating to overnight visits reported by some asylum seekers from unidentified men, and that's quite right. But other asylum seekers, and we give you the references in the list, were visited overnight by a man they identified as the same DGIE officer who had met them at the airport. The DGIE's other actions under the Israel-Rwanda agreement recorded in UNHCR's evidence include physically shutting transferees out of its premises, notwithstanding UNHCR actually being physically present while that was happening and trying to intervene on behalf of the asylum seekers. The DGIE also threatened certain transferees who complained to the ministry, rather than speaking directly to DGIE, that if they did so again, their temporary residence permits would not be renewed. So Israel-Rwanda is the first category of refoulements and associated abuses in which the DGIE was implicated. None of this is mentioned in the Divisional Court statement. The DGIE was also involved in the expulsions and threatened expulsions of the nationals of the non-African country in apparent collusion with the authorities of that state. Some of the features of that category of expulsion, which of course occurred for people who sought to claim asylum inside Rwanda, include the confiscation in 2 instances of an individual's passport at the request of the country of nationality, threats of imminent refoulement, which was said to be happening at the request of the country of origin of the asylum seekers, and orders to leave Rwanda within 12 hours on pain of being deported directly to the asylum seekers' country of origin. Again, about this, the Divisional Court is silent. Turning now, and of course, the third category of reformers, the recent airport pushbacks, the DGIE is again involved. That is clear from the government of Rwanda's own responses, and we've given you the we've given you the references for that. I'm now at 6A, Roman numeral 2 of the speaking note. The extra legal role played by the DGIE in Rwanda's RSD process is a long-standing problem. In 2016, in the context of the Israel-Rwanda agreement, UNHCR noted, this is an internal contemporaneous note, I'm giving you the reference, that the DGIE appeared to be, and I quote, taking on a larger role than that which is afforded by the law, including by reviewing and turning away applications. The same internal UNHCR document noted that in February 2015, Midimar, that's the precursor to Minimar, a lot of acronyms here, so that the minister referred in a letter to UNHCR to DGIE verifying the status of applications, especially for security reasons, that's the quote. The same internal UNHCR document explains that in May 2016, the minister themselves orally informed UNHCR that the DGIE has the right to make decisions on asylum claims. UNHCR's evidence before the Divisional Court confirmed the problem to be ongoing. We've given you the reference. LB3 explains that of the asylum claims of which UNHCR is aware, 8% were summarily refused by the DGIE, and of course you'll see the note at the top of what Mr. Hussain referred to as the reform on table, that UNHCR considers the 8% figure to likely be an underrepresentation of the true numbers. The DGIE's unacknowledged gatekeeper role extends also to the DGIE making recommendations to the RSDC, which are not notified to the asylum seeker. UNHCR is confident and unequivocal that this is happening. Now at paragraph 6A, Roman numeral 4, the government of Rwanda now points out that the DGIE has no authority to decide asylum claims in Rwandan law. UNHCR has no argument with that proposition, but is unequivocal that the practice is occurring. You also have the point from Mr. Hussain, which I won't return to therefore, that the DGIE has made decisions based upon unspecified security concerns, we've given you full references, and based upon, and that's in the case of the individuals from a non-African country, Rwanda's external relations, it would appear. And we do say that here the question which has to be confronted, that has not been, whether by the Secretary of State or the Divisional Court, is not whether future asylum refusals and reform will occur in precisely the same form under the METP. Rather, the questions are whether Rwanda's immigration authorities have in any way been reformed, restructured. Second, whether anything in the MEDP will stop them from engaging, as they have for years, in what one might colloquially term off-the-books decision-making. That is, decision-making that may never be formally acknowledged and which may turn upon impermissible considerations. And third, how resistant unacknowledged off-the-book decision-making is to external monitoring. The MOU and the process not verbal do, of course, require objective and impartial decision-making in accordance with the Refugee Convention, but that is an aspirational assurance, a considerable distance from the DGI's decision-making in what it considers to be sensitive cases. And there is nothing at all in the assurances to tell us how and when Rwanda is to move from its current mixture of acknowledged and unacknowledged decision-making, permissible and impermissible concerns, to a system of objective and impartial decision-making. Now, my lords, can I ask how you would prefer me to proceed?
You had my attention so completely I hadn't noticed the time. But I think we'll pause now and start again at 2 o'clock. And could I ask that somebody have a look at the loop, and let's hope we can get it up and running by 2 o'clock.
I'm very good.